David Parker.
Thank you, Mr Speaker. I also rise to support the first reading of this bill. As the Honourable Leanne Dalziel has already said on our behalf, we intend to support this measure. The background to it is well set out in the regulatory impact statement, where the linkages between New Zealand and Australia are set out, and it's probably worth repeating some of those facts to the House. In 2006, over 900,000 Australians visited New Zealand, and well over 1 million New Zealanders went the other way and visited Australia. Exports from Australia to New Zealand totalled $7.6 billion in the year to June 2006, and from New Zealand to Australia totalled $6.8 billion. That was the export of goods, those two figures. In terms of services from New Zealand to Australia, $2.3 billion, and from Australia to New Zealand, $3.5 billion. So I suppose that and as well as that, there are very significant investments in New Zealand, about $68 billion worth of Australian investments in New Zealand and about $25 billion of New Zealand investments in Australia. The first point to make in respect of those trade figures is rather a tangential one to this bill, and that is that there is a trade imbalance with Australia, which reflects the fact that the Australians have got a more successful economy than ours, which reflects, in my view, a fundamental difference between savings and investment policy on both sides of the Tasman. Australia has long had a very good savings record. It does it through workplace savings for superannuation. They've had workplace savings for superannuation on a compulsory basis now for a couple of decades. In contrast, New Zealand hasn't, despite the good efforts of Sir Roger Douglas back then under the Kirk government in designing a suitable scheme for a start, which was then trashed by Mr Muldoon as his way to buy his way into New Zealand's into success in the election. And was it 72 or 75? 75 in the 75 election. Thank you, Sir Roger. Since that time, New Zealand really hasn't caught up with Australia in terms of savings and investment, and I think that's probably the main underlying reason why they have a trade surplus with New Zealand. They've got deeper investment markets and they have more money to invest in productive enterprise and to spend on the purchase of New Zealand businesses than we have to spend on the purchase of theirs, and as a consequence we suffer in comparison with Australia. And I think it's good that we make this measure, but it does cause me to reflect on some of the things that this government's not doing in terms of bridging this gap between Australia and New Zealand. They say that that's one of their driving ambitions, is to close the gap between New Zealand and Australia. These regulatory measures actually don't cut the mustard. They're good things to do, and I don't disapprove of them being done. And indeed, this bill is a result of work that was initiated by the Honourable Leanne Dalziel when it was a Labour-led government. But the underlying reality is that the government is not improving New Zealand's saving and investment record in any material way, and indeed they've done some things that are to the disadvantage of it. Their opportunities to make fundamental changes to the economy that they have had, they've missed. They had a report from a tax working group that was good, considered work. It was a wise thing on the part of the government to commission that report, but when they got it, they just picked the eyes that the National Party would ordinarily pick out of any such policy. They did what they always do, which is they will end up increasing the relative tax burden of low and middle income people to the benefit of higher income people who will get most of the tax breaks that are funded through.
I'll ask the member to come back. This is about New Zealand, and I'll ask the member to bring his debate back, please.
Thank you, Mr Speaker. And so, coming back to the bill, that's the reason why the regulatory impact statement records such a gap in the export of goods from Australia to New Zealand compared with the smaller amount we export to Australia, and why we have a trade balance. Now, in terms of the Trans-Tasman Proceedings bill, it obviously does some sensible things. At the moment, if you have a judgment for anything other than a sum of money, you can't automatically enforce it in New Zealand, and this bill fixes that by saying if there's an appropriate judgment in an Australian court, then ordinarily it can be enforced in New Zealand, whether it's just a simple judgment on a debt or whether it arises from some other cause of action like breach of contract or tort or whatever the cause was. Secondly, it says that proceedings commenced in an Australian jurisdiction can be served here. Thirdly, it says where there are Australian proceedings afoot in Australia, then interim relief can sometimes be granted in New Zealand under those proceedings, so that if there's an Australian proceeding and there are assets that might be at risk that are sitting in New Zealand and there was some desire to get some interim injunctive relief to stop the disposal of those assets, that might be the sort of thing that could now occur. Someone could come to the New Zealand courts and say on the basis of those Australian proceedings, then there ought to be assets that can't be sort of shuffled out of New Zealand to some other jurisdiction and out of the jurisdiction of any court to attach should the court action in Australia be successful. There are some areas where you can't get interim relief. I'm not 100% sure on the meaning of those clauses, but I will be interested to better understand the detail of those provisions when it comes to the Select Committee, and I'm sure that will be clarified. In terms of choice of jurisdiction, there are protections in this legislation to make sure that no one just goes and chooses the jurisdiction which they think will be best to their case. In terms of the differences in the law that there might be between Australia and New Zealand, rather than what is the proper and best court, depending on the background to the case. And so there is ability here for the court to actually say no, it shouldn't be heard there. So you can apply for a stay of proceedings in a would be if the court's convinced that Australia is the more appropriate forum for the hearing of that dispute. Another provision is that the courts can now enforce contractual agreements between the parties as to their court of choice. Parties, when they enter into what court they are going to have their disputes resolved by. So it could be quite common for a New Zealand business doing business with an Australian-based company to, in their form of contract, agree that the contract disputes will be determined in Australia according to Australian law, or conversely in New Zealand according to New Zealand law. In either case, those things will now be able to be enforced in New Zealand. That would be enforced by this legislation and a New Zealand court. In respect of agreements to litigate in Australia, the companion legislation, which will be the Australian legislature, will have a similar effect over there. Mr. Speaker, one of the other important changes made to the bill is facilitating remote appearances and the remote giving of evidence on both sides of the Tasman. This will now be made easier, and that's appropriate. We had a discussion earlier in the day as to how that's more appropriate in respect of civil proceedings than it is in respect of criminal proceedings, because of course in criminal proceedings the defendant has a right to see the witnesses and to test their evidence in a way that's more important given the risk to their liberty if they're convicted of a crime, compared with the less important considerations in terms of personal liberty that arise in respect of civil proceedings with which this bill deals. Another part of this bill is to give force to various tribunal findings, which will now be able to be enforced in New Zealand, despite there not being, in other words, some of the ways in which judgments can be enforced applied not just to decisions of certain other listed tribunals, and that too is appropriate. The regulatory impact statement, as Leanne Dalzell said, is a good regulatory impact statement. I must say that I do find it beneficial that it's included in the bill. Although in a perfect world we would have a lot more time to prepare before we speak on these debates, on occasions we come here without having had the opportunity to download the regulatory impact statement, and I think it's useful for members and aids the integrity of the regulatory impact statement process if the form of the regulatory impact statement is included in the bill rather than put in some other document. It enables people that are interested in those matters to have easy access to them so that they can assess for themselves whether they think the regulatory move proposed is justified. In this case, I think the regulatory impact statement makes it clear that this new regulatory